You're pulled over. The officer leans slightly closer to your window and says something that instantly raises the stakes. "I smell marijuana." In that moment, everything changes. What was a routine traffic stop can suddenly turn into a search, a detention, or even an arrest, based on just a few words. But here's the question. When an officer makes that claim, are you legally required to comply with everything that follows, or do you still have rights you can assert in that moment? Let me know your answer in the comments below. According to official court records and law enforcement procedures, the claim of detecting the smell of marijuana has long been used as a basis for probable cause. Probable cause is a legal standard under the Fourth Amendment that allows officers to conduct searches without a warrant if they have a reasonable belief that a crime is being committed. Historically, courts in multiple jurisdictions have accepted the odor of marijuana as sufficient justification for vehicle searches. However, the legal landscape has changed significantly over the past decade. With the legalization or decriminalization of marijuana in several states, courts have begun to re-examine whether the smell alone still meets the threshold for probable cause. According to state appellate decisions, some jurisdictions now require additional evidence beyond odor, while others continue to uphold the traditional standard. The background here is critical. In earlier decades, marijuana possession was broadly illegal across the United States. As a result, courts routinely accepted an officer's claim of smell as a reliable indicator of criminal activity. But as laws evolved, so did the legal interpretation. In some states, courts have ruled that because marijuana can be legally possessed under certain conditions, the smell alone may no longer indicate a crime. Now let's look at what typically happens during these encounters. According to police procedure manuals, once an officer claims to smell marijuana, they may ask questions, request consent to search the vehicle, or proceed with a search if they believe probable cause exists. At this point, the interaction becomes legally significant. Every word spoken can influence the outcome. One interpretation of the law is that officers are acting within their authority when they rely on sensory perception, including smell. Another perspective raised in court cases is that such claims can be subjective and difficult to verify, which raises concerns about potential misuse or overreach. Courts have acknowledged this tension and, in some rulings, have placed limits on how far such claims can justify further action. This is where legal awareness becomes essential. In my legal analysis, individuals have the right to remain silent and the right to refuse consent to a search. These rights are grounded in the Fourth and Fifth Amendments. The Fourth Amendment protects against unreasonable searches and seizures, while the Fifth Amendment protects against self-incrimination. Courts would likely examine whether these rights were clearly invoked during an interaction. This is for informational purposes and not legal advice, but it's important to understand that how you respond in that moment can shape the legal outcome. A calm, clear, and lawful response can preserve your rights without escalating the situation. On the other hand, unclear or inconsistent statements may complicate matters. A key turning point in legal discussions around this issue came with recent appellate rulings questioning the reliability of odor-based probable cause in states where marijuana is partially or fully legal. Some courts have ruled that additional indicators, such as visible evidence or admission, may be required. Others maintain that odor alone still justifies further investigation. From a real-world perspective, this means outcomes can vary depending on the state, the officer's observations, and the specific circumstances of the stop. Supporters of the traditional approach argue that law enforcement needs flexibility to act quickly. Critics argue that reliance on subjective claims can lead to inconsistent enforcement. So where does that leave the average driver? It means understanding your rights is not optional, it's essential. Knowing what you can and cannot say and how to respond lawfully can make a significant difference in how the situation unfolds. As we continue, we'll break down the exact four-word response that legal experts often recommend, why it matters, and how courts interpret it in real-world cases. As we move forward, it's time to address the core of this discussion, the specific response that legal professionals often recommend in situations where an officer claims to smell marijuana. The phrase is simple, clear, and legally grounded. I do not consent. These four words are not magic, and they don't automatically end an encounter. But in my legal analysis, they serve a very specific and important purpose. They clearly communicate that you are not giving voluntary permission for a search. That distinction matters significantly in court. According to established Fourth Amendment doctrine, There is a major legal difference between a search conducted with consent and one conducted based on probable cause. If you give consent, even casually, courts often consider that permission valid, and it becomes much harder to challenge the search later. However, if you clearly state that you do not consent, the burden shifts entirely onto the officer to justify the search under legal standards. One interpretation of this principle is that asserting your rights creates a clear legal record. Another perspective raised in court decisions is that officers may still proceed with a search if they believe probable cause exists, but the absence of consent becomes a critical factor in later legal review. This is where many cases turn. According to appellate rulings, courts frequently examine whether consent was freely and voluntarily given. If there is any ambiguity, if a driver hesitates, uses unclear language, or appears to agree under pressure, it can weaken their legal position. In contrast, a calm and direct statement like, "I do not consent," removes that ambiguity. This is for informational purposes and not legal advice, but legal professionals consistently emphasize the importance of clarity. You are not required to argue, resist, or escalate the situation. In fact, doing so could create additional legal complications. The goal is not to challenge the officer in the moment. It's to preserve your rights for any legal review that may follow. Now, it's equally important to understand what this phrase does not do. It does not prevent an officer from taking further action if they believe they have lawful grounds. Courts would likely examine the totality of the circumstances, including the officer's observations and any additional evidence. So, while these four words are powerful, they are part of a broader legal framework, not a guaranteed outcome. Historically, courts have reinforced the idea that individuals must actively assert their rights. Silence alone is not always enough. In some cases, courts have ruled that failing to clearly refuse consent can be interpreted as passive agreement. That's why precise language matters. From a real-world standpoint, many legal defense strategies rely on whether consent was given. If a search is later challenged, one of the first questions asked is simple: did the individual agree to the search? If the answer is unclear, it often benefits the prosecution. If the answer is clearly no, it strengthens the defense's position. Supporters of this approach argue that it promotes accountability and ensures that searches are conducted within constitutional limits. Critics may argue that it complicates interactions between citizens and law enforcement. But courts have consistently upheld the principle that constitutional rights must be clearly protected, even in routine encounters. In my professional opinion, the key is balance. You can assert your rights calmly and respectfully without escalating the situation. Tone, body language, and clarity all matter. Courts would likely view a composed and respectful assertion of rights more favorably than a confrontational response. Now, here's something to think about. If you were in that situation, would you feel confident calmly saying, "I do not consent," or do you think most people hesitate in the moment? Share your honest answer in the comments below. I want to understand how people really react under pressure. Once those words are said, "I do not consent," the situation doesn't simply stop. In reality, this is where things become more legally significant. According to law enforcement protocols and court records, officers may respond in several different ways depending on the circumstances, the jurisdiction, and what they believe they are observing. In some cases, the officer may step back and choose not to proceed further without additional evidence. In other situations, the officer may continue questioning, attempt to build probable cause through observation, or proceed with a search if they believe legal justification exists. This is why understanding the next phase is critical. From a legal standpoint, courts apply what is known as the totality of the circumstances test. This means they look at everything: the officer's observations, the environment, the behavior of the individual, and any statements made during the interaction. One interpretation is that even without consent, a search can still be upheld if probable cause is established through other factors. Another perspective raised in court is that reliance on subjective elements, like smell alone, can be challenged, especially in jurisdictions where marijuana laws have changed. This is for informational purposes and not legal advice, but one of the most important principles here is consistency. After stating, "I do not consent," maintaining a calm and consistent approach is essential. Contradictory behavior, such as verbally refusing consent but physically cooperating in a way that suggests agreement, can create ambiguity. Courts have examined such contradictions in past cases, sometimes ruling that the overall conduct implied consent despite verbal refusal. A key turning point in many legal cases involves how the interaction is documented. Body camera footage, dash cams, and audio recordings often become central pieces of evidence. Courts review not only what was said, but how it was said. Tone, clarity, and timing all matter. In my legal analysis, a clear, respectful, and non-confrontational assertion of rights is far more effective than emotional or aggressive responses. Let's consider a typical scenario. An officer claims to smell marijuana and asks to search the vehicle. The driver responds calmly, "I do not consent." The officer then asks additional questions, perhaps attempting to elicit statements that could justify further action. At this point, the Fifth Amendment becomes relevant. The right to remain silent allows individuals to avoid self-incrimination. Courts would likely examine whether any statements made afterward contributed to establishing probable cause. Historically, courts have ruled that voluntary statements, even casual remarks, can be used as evidence. For example, admitting to recent use, possession, or even nervous explanations can shift the legal balance. This is why many legal professionals advise limiting conversation beyond basic identification and compliance with lawful orders. From a federal versus state perspective, the situation becomes even more nuanced. Some states have explicitly limited the role of marijuana odor as probable cause, while others still permit it as a primary factor. Courts in those jurisdictions interpret the same interaction differently, which means outcomes can vary widely depending on location. Real-world impact analysis shows that individuals who clearly assert their rights and remain consistent tend to have stronger legal positions if a case proceeds to court. On the other hand, individuals who provide mixed signals or engage in extended conversation may unintentionally weaken their position. Supporters of current law enforcement practices argue that officers need discretion to assess situations quickly and ensure public safety. Critics argue that subjective factors like odor can lead to inconsistent enforcement. In my professional opinion, both sides highlight the importance of clarity, both in the law and in how individuals respond during encounters. Legal risks of noncompliance or misunderstanding are also important to consider. Refusing consent does not mean refusing lawful orders. If an officer issues a lawful command, such as exiting the vehicle, failure to comply could create additional legal complications. Courts would likely distinguish between asserting rights and obstructing an investigation. This is where the balance becomes critical. You are asserting your rights, not resisting authority. That distinction is fundamental in how courts interpret behavior during these encounters. Now here's a question for you. If an officer continues questioning after you clearly refuse consent, do you think most people can stay calm and consistent, or do you think pressure in that moment changes how people respond? Share your thoughts in the comments below. I want to hear your perspective. As we move into the next part, we'll examine real case-style outcomes, how courts have ruled in similar situations, and what ultimately determines whether a search is upheld or challenged successfully. As we reach the final stage of this discussion, it's time to look at how situations like this actually play out in court. Because at the end of the day, what matters most isn't what happens on the roadside. It's how that interaction is interpreted later under the law. According to multiple appellate court rulings, one of the first questions judges examine is whether the search was conducted with consent or based on probable cause. This is where those four words, "I do not consent," become highly significant. In many cases, courts have ruled that when consent is clearly denied, the legality of the search depends entirely on whether the officer had sufficient independent justification. In one interpretation of similar cases, courts have upheld searches where officers combined odor with additional observations, such as visible contraband or clear admissions. Another perspective raised in court is that odor alone, especially in states where marijuana laws have changed, may not always meet the threshold for probable cause. This evolving legal landscape has created a split in how courts evaluate these encounters. This is for informational purposes and not legal advice, but one consistent theme across cases is clarity. When individuals clearly assert their rights and avoid making unnecessary statements, courts tend to focus strictly on the officer's justification. On the other hand, when individuals engage in extended conversation or provide inconsistent responses, those details often become central to the case. A key turning point in many legal outcomes is the presence of recorded evidence. Body camera footage has changed how courts analyze these situations. Judges can now review tone, timing, and exact wording. In my legal analysis, a calm, respectful statement like, "I do not consent," followed by consistent behavior, creates a strong and defensible record. Let's look at the broader implications. The Fourth Amendment exists to protect individuals from unreasonable searches, while the Fifth Amendment ensures protection against self-incrimination. These are not abstract concepts. They are practical rights that apply in everyday situations like traffic stops. Courts would likely examine whether these rights were clearly invoked and respected during the interaction. From a real-world perspective, the outcome of these encounters often comes down to three factors: what the officer can legally justify, what the individual says or does, and how clearly the interaction is documented. This is why legal awareness is so powerful. It doesn't guarantee a specific outcome, but it ensures that your rights are preserved throughout the process. Supporters of current legal standards argue that officers need flexibility to respond to potential violations. Critics emphasize the importance of protecting constitutional rights from subjective interpretations. In my professional opinion, both perspectives highlight the need for balance: effective law enforcement on one side and clear enforceable rights on the other. The long-term implication is clear. As laws continue to evolve, especially around controlled substances, courts will likely keep refining how probable cause is defined. But one principle remains constant: individuals who understand their rights and assert them clearly are in a stronger legal position than those who do not. So now, let's bring it back to you. If you were in that situation, an officer claims to smell marijuana, asks to search your vehicle, and the pressure is on, would you stay calm and confidently say, "I do not consent"? Or do you think most people would hesitate in that moment? Share your honest answer in the comments below. Your perspective matters, and this is a conversation worth having. And if you found this breakdown helpful, make sure to subscribe to the channel for more real-world legal insights that can actually impact your daily life. Hit the bell icon so you never miss an important update, and drop a comment telling me what topic you want the next video to cover, whether it's traffic stops, your legal rights, or any situation you want explained clearly and professionally. Because at the end of the day, knowing the law doesn't just inform you, it protects you.